USCIS Policy Memorandum PM-602-0199, published May 22nd, 2026, essentially is bringing a pivotal change in the way USCIS officers will now be able to adjudicate 245I adjustment of status applications. It is directing the officers to not treat adjustment of status as a matter of right for the public, but instead treat it as an extraordinary measure of immigration relief. It is encouraging USCIS officers to rigorously exercise unfavorable exercise of discretion to deny adjustment of status applications. The purpose of the policy memorandum is to discourage the public from bringing forth adjustment of status applications with USCIS and instead employing consular processing abroad. Now, the following categories of applicants that typically utilize adjustment of status with the USCIS are at the highest risk. People who entered the United States on a parole or single intent visa document are going to be at the higher risk of this policy memorandum. Now, non-immigrants who are here in this country on a dual intent visa, such as H-1B, are going to be facing moderate scrutiny, while people who are here seeking adjustment of status as immediate relatives of U.S. citizens are going to be probably subjected to the lowest form of scrutiny. In practice, what it means for you is that as an adjustment of status applicant, you can no longer just apply because you meet the eligibility criteria on the face of it, or your immigrant visa has now become available to you in the United States. You must build positive equities in your application, such as you have to have a stark logging of maintenance of status, especially if you have been present in the United States for years prior to applying for a green card. You must show that you have maintained status and complied with the terms of your non-immigrant visas in the past. And you should not have any prior unauthorized employment or other inconsistencies with your prior applications. You must have very good positive equities that will warrant a favorable exercise of discretion of a USCIS officer. Otherwise, they could deny it. And to avoid a denial on the face of your application, you must build your application so robustly that if USCIS denies it, you have documentary evidence to argue and prove that you had built up positive equity, such as you can show that you have ties in the community, you have a clean record, you have maintained status, you have complied with terms of your previous non-immigrant visas. For more information and for further clarification on this much rather daunting policy memorandum, you should contact a very seasoned immigration attorney, and we are here to help you.